They say Americans don't have any culture, but one thing that is arguably distinct to Americans is our proclivity towards bringing lawsuits, many of which are considered frivolous lawsuits. According to the Legal Information Institute, a frivolous lawsuit is one in which the claim lacks any arguable basis in law or fact and is intended to harass, delay, or embarrass the opposition. I'm sure many of us can think of an example of this that we've heard of in the news. But if you were to dig into these cases, you might find that there's more to them than meets the eye. Hi, I'm Cam.
And I'm Dev.
And you're listening to Criminalish, a true crime podcast where two best friends trade stories ranging from the wild and wacky to the downright messed up. So, due to the heavy content of our last couple episodes, I wanted to take a bit of a different approach and lighten the mood some. So today I'm going to be telling actually two different stories of some quote unquote frivolous lawsuits. Although I will say that these two cases are infamous for very different reasons. Even though this episode is lighter, I would like to extend a couple of trigger warnings, specifically for substance use, burn injuries, and also just some capitalist BS. So before I get into today's episode, what you drinking, friend?
So I'm going to give y'all a little behind the scenes scoop. And Cam told me that this would be the perfect episode to have a nice glass of wine with. So I pulled out one that I have been saving for a little minute now. And that is the 19 Crimes Cali Red wine by Snoop Dogg. And I've never had this wine before. I'm going to try it for the first time today. But she's 13.5%. And according to the back of her bottle, the composition is red wine. So that's what we're going to be drinking today. And you know the best thing about this wine, friend? It was buy one, get one free at Publix. So now I have two bottles.
You know I love me a good BOGO.
We love a BOGO in this household. What you drinking, friend?
I am drinking a little mocktail that I made. It is a blueberry lemonade seltzer type of drink. I just blended up some blueberries, lemon juice, added in some seltzer water and honey to sweeten it up some. And I also added some apple juice just to make it a little bit sweeter because it was a little bit too bitter for me at first. If you're watching on YouTube, you can see it for yourself. And if you're not, go to YouTube and check it out. Okay, so for our first mini story, I'm going to be telling you about the case surrounding Jesse Dimmock and Jared and Lindsay Rowley. Before I get into the details, have you heard about this case, Dev?
Absolutely not.
So, on September 12th, 2009, Jesse Dimmock forced his way into the Topeka, Kansas home of newlyweds Jared and Lindsay Rowley and held them at knife point. Jesse, who was originally from Denver, Colorado, and was 27 years old at the time, had fled to Kansas to avoid a murder charge. The police wanted to question him about the murder of a man named Michael Curtis. The murder had taken place in a motel in Aurora, Colorado, 2 days prior to Jesse forcing his way into the home of the Rowleys. According to reporting, both Dimmock and Curtis likely suffered from substance use disorder, and Dimmock had lured Curtis to the motel under the guise of a drug deal and had stabbed Curtis to death before stealing his wallet and drugs and fleeing the scene. When Jesse Dimmick entered into the home of the Rowleys, he told them that he was being chased by someone who wanted to kill him, i.e. the police. The couple, obviously scared for their lives, fed Dimmick snacks and watched movies with him until he fell asleep, at which point they were able to flee and alert police. Police then stormed the home and detained Jesse Dimmick. And actually, while they were arresting him, one of the officers' rifles accidentally went off and shot him in the back. So he also had to go to the hospital, but he did live.
Wait a second. I'm sorry. So much just happened over the last 2 minutes of you talking.
Yes.
Wow. So you're telling me they escaped their assailant by treating him like a small child?
That is exactly what I'm telling you. They made him think that they were on his side. They were going to protect him and fed him, watched movies with him, probably tucked him in. I'm kidding. I'm making up that part. But yeah, they basically waited until he fell asleep. And I'm sure they were like, you think we can go? Yeah, I think we can go. Are you sure? Should we go? I'm sure they themselves couldn't believe it. But also, I'm sure they were also extremely scared.
Right. Because you just had a man storm in your house and hold you at knife point and then be like, can we turn on Shrek? Like, I just... I'm sorry. I know I should take this more seriously, but that image of them tucking this grown man in like he's 6 is the only visual, the immediate visual that you gave me. That reminds me so much of when I fight with my niece that it's bedtime. And I'm like, just go lay down and turn the TV on and wait till she falls asleep. That's what they did.
Yeah, that is pretty much what they did.
Okay, please continue, Fran.
So this took place in September 2009. In May 2010, Jesse Dimmick was convicted of 4 felonies, which included 2 counts for kidnapping. He was sentenced to 10 years and 11 months for his part in kidnapping the couple. After being charged and sentenced for the kidnapping, he was sent back to Colorado to face the murder charge, where he was eventually convicted and sentenced to 37 years. Just to clarify, these sentences are going to run consecutively to each other. So he will do his time for the kidnapping charges, and then he will do time for the murder charge. In regards to the murder charge, he was originally charged with first-degree murder, since the prosecutors alleged that he had lured Michael Curtis to the motel with the promise of a drug deal. However, Jesse Dimmick was able to plead guilty, and the charge was lessened to second degree. So now we get to the lawsuit. In September 2011, the Rowleys filed a civil suit against Jesse Dimmick, where they sought $75,000 for the home intrusion and emotional damages. And you would think that this would be the end of the case, but it is not. Because a couple months later, Jesse Dimmick filed a breach of contract lawsuit in response, in which he claimed that the couple had made an oral agreement that they would hide him from the police in exchange for an quote-unquote undisclosed amount of money. And in his handwritten court documents, the articles made sure to specify that these court documents were handwritten.
Stop.
He was seeking $235,000, partly for the hospital bills that came from him being shot by the police. And here's a quote from the court documents that he submitted. I, the defendant, asked the Rowleys to hide me because I feared for my life. I offered the Rowleys an unspecified amount of money, which they agreed upon, therefore forging a legally binding oral contract. In response, the lawyer for the Rowleys simply stated that there was no contract, and even if they'd made this agreement, it would not be legally binding because it was made under duress. And in January 2012, a judge dismissed the lawsuit that Jesse Dimmick had filed against the Rowleys.
Child, I could not imagine. I file suit for somebody busting up in my house and holding me at knife point. I file a lawsuit against them, and their response is to file a lawsuit against me? Because how dare you tell the police where I was at when I was holding you hostage? How dare you?
Right.
We shared snacks together. We watched Frozen. We watched Frozen on the couch together. How dare you?
Exactly.
Bro.
I may have held you at knife point, but I thought we were friends.
We have a legally binding oral contract. Bro.
I threatened you and you said you would do what I said.
Right.
What happened?
I'm not gonna lie to you though. That whole thing gives teacher, she hit me.
Literally.
Oh, wow.
Yeah. Reading about that, I was baffled. But I think that is a good example of what a lot of people think of when they think of frivolous lawsuits. The main case that I want to discuss today talks about another one that you probably have heard of. So, Dev, have you ever heard of the case of the woman who sued McDonald's because her coffee was too hot?
Absolutely, I've heard of that case.
For any listeners who haven't heard about this case, the way the story goes is that in 1992, a 79-year-old woman bought a takeout cup of coffee from a McDonald's drive-thru in Albuquerque, New Mexico, and spilled it on her lap, causing burns. She sued McDonald's and was awarded nearly $3 million in punitive damages by a jury for her injuries. And I know that in the way the story was framed, and even when I heard this story growing up, many people were wondering why she won so much money, because shouldn't she have known that the coffee was hot? And even then, she spilled it on herself, right? So how was McDonald's at fault? So what I want to do today is to really get down to the facts and what really happened in this case, and why it's thought of as the prime example of a frivolous lawsuit. So on February 27th, 1992, the plaintiff in this case, 79-year-old Stella Liebeck, was sitting with her grandson in a car parked in a McDonald's parking lot where she'd just gotten coffee and breakfast. She was attempting to add cream and sugar to the cup, which was between her knees, when the cup fell over and all the coffee spilled onto her lap. Now, this was not just regular hot coffee. Due to McDonald's policy, coffee needed to be served at 180 to 190 degrees Fahrenheit. When the coffee spilled on Mrs. Liebeck's lap, it caused third-degree burns and resulted in her needing skin grafts. For a little bit of context, coffee at that temperature can cause third-degree burns in 3 to 7 seconds if it comes into contact with human skin. Stella was also wearing sweatpants, which absorbed the coffee and kept it in contact with her skin for even longer. She ended up having to rip off the sweatpants, and her grandson wrapped her in a bedsheet and placed her in the back seat, where she began to feel faint and nauseous. Stella was unable to see doctors until nearly an hour after the accident due to having to go to 2 different hospitals. She was in so much pain that she went into shock, and according to medical staff, she almost died. Over 16% of her body had been burned, and 6% of these burns were third-degree burns. The skin grafts that she needed caused scarring and permanent disfigurement, and she did not get out of bed for 3 days and spent a total of 7 days in the hospital. Doctors wanted her to stay longer, but Stella didn't want to because of the cost of the care. She'd already incurred nearly $10,000 of treatment. Stella, for more context, was a retired department store clerk and did not have much money in her savings. she had been saving up to make a down payment on a small house that was close to her daughter. And this was actually the reason that she'd recently moved to Albuquerque from Tucson, Arizona. And to add insult to injury, doctors told her that she would need another $10,000 for continued care. So this was also not the first time that someone had been burned by coffee sold by fast food restaurants. McDonald's specifically had received nearly 1,000 reports of injury from its coffee. And these injuries included other third-degree burns, and in some of these cases, they'd even paid settlements. Mrs. Liebeck's daughter, Judy, and son-in-law wrote a letter to McDonald's on their mother's behalf and urged the company to review the coffee machine and coffee-making process to determine if there was some kind of error in the coffee she was served. And if there wasn't, they also urged McDonald's to reevaluate the temperature that their coffee was being served at. Now, Mrs. Liebeck and her family had initially offered to settle the case for $20,000 just to cover her medical expenses. But McDonald's would not go over $800. And in their minds, this was more than generous. From their perspective, McDonald's didn't feel that they were responsible for people spilling their coffee. But this was not the focus of the issue for the Liebeck family. They were focused on the fact that McDonald's coffee was being served at a dangerously hot temperature. And the family just wanted them to bring the temperature down so that other people wouldn't go through what she had to go through. They really wanted to settle this out of court, but McDonald's refused this offer, and they never attended any of the mediations that the Liebeck family had scheduled. They suggested that Mrs. Liebeck was at fault for not removing her clothes fast enough, and that her burns were more severe due to her age, not the temperature of their coffee. And McDonald's actually wanted the case to go to trial because they were convinced that no jury would rule against them. In their minds, their customers wanted their coffee hot, and also at this time, the state of New Mexico had never ruled in favor of a plaintiff in a product liability case. So they also felt that precedent was on their side. I'm going to pause there for any initial thoughts.
The arrogance. That's the initial thought. The arrogance. The arrogance to think that just because nobody else has ever won means she wouldn't win against you. That's insanity to me. And it's also insane to me that you offered this woman $800. I'm sorry, but even in, you said 1992, correct?
Mm-hmm.
McDonald's was $1 billion company. You're a $1 billion company and you offered her $800 in 1992. So at max, that's like $1,600 now at max.
When all she was seeking was the cost of her medical bills. She wasn't seeking additional money.
Exactly. That's despicable. And then I think it's also extremely disrespectful to ever say that, well, if she had just removed her clothes faster, then she wouldn't have been burned. So my ability to strip naked in panic is what warrants whether or not I get money from you when the initial cause of said burning was your product.
Well, in their mind, it was her age. Her skin's older, so it was just more susceptible.
I was actually just about to bring that point up too, because to be honest, I don't think they're completely wrong in that older aged skin just doesn't have the snapback of younger skin. It just doesn't. But if we're talking 3rd degree burns, I'm sorry, that's not an old skin issue. Old skin is, crow's feet and veins and that kind of thing. She may have been more red. She may have been more reactive. A 3rd degree burn happens to any kind of skin.
Right.
That's insanity.
So I give all of this context to clarify that going to court was really Stella and her family's last resort. Stella had never sued anyone before, but some of her friends were able to connect her to an attorney named Reed Morgan, who had dealt with a similar case a few years prior in which a Houston woman had sued McDonald's after suffering third-degree burns from their coffee and settled for a little less than $30,000. In this case, Stella and her family sued McDonald's for gross negligence and for selling a product that was, quote, defectively manufactured and unreasonably dangerous, end quote. So on August 8th, 1994, the trial began. There were multiple experts and scientists on both sides, as well as presentations of photos of Mrs. Liebeck's injuries. A burn expert on Mrs. Liebeck's side testified that liquid at 160 degrees Fahrenheit only takes 20 seconds to produce a third-degree burn. At 180 degrees Fahrenheit, it takes 12 to 15 seconds. And at 190 degrees, a third-degree burn can occur in less than 3 seconds. This is just a reminder at the time that McDonald's policy was to serve their coffee at 180 to 190 degrees Fahrenheit. This was 20 to 30 degrees warmer than any of their competitors.
Interesting.
In his testimony, McDonald's quality assurance manager admitted that they had not consulted with burn experts about the temperature of their coffee, and executives had decided not to warn customers about potential injuries, even though they were aware of the risk. On top of this, they had no intention of changing their policies, even though some of the cases they'd faced related to the temperature of their coffee had involved children and infants. And you might ask yourself, okay, so this isn't the first case that's happened where somebody burned themselves with their coffee. Why wouldn't they just lower the temperature a little bit? And this was because the corporate bigwigs at McDonald's had calculated how much money they'd lose if they lowered the temperature of their coffee and determined that it would actually be less expensive to settle the burn cases as they came.
Wow. It's cheaper just to let people sue us than to just take the initiative of not getting sued.
Right.
See, now I want to see that Excel spreadsheet. Those are the numbers I'm trying to see with this whole case. I want to see the Excel spreadsheet that told y'all it was less expensive to just get sued. That's crazy.
Yeah, and I didn't exactly understand the reasoning behind it, but it was essentially that when coffee is served at a higher temperature, it has a higher shelf life. So I think it relates to how the beans are processed or something like that. But yeah, that was the way that they justified it. It would just be less expensive for them to just give people money than to actually make their coffee a little bit safer. So, as they did to you, to many in the court, the McDonald's defense team came off as arrogant and like they didn't see anything wrong with what they were doing. So, on August 17th, 1994, the jury found that Mrs. Liebeck was 20% at fault for her injuries, so they reduced the compensation associated with her hospital bills accordingly. She was awarded $160,000 in compensatory damages. And the large amount that was seen in headlines came from the award associated with the punitive damages, which equaled 2 days' worth of revenue from coffee sales. And that's what totaled $2.7 million. And just in case anyone doesn't know what punitive damages are, those are damages awarded separately from damages associated with a particular event and are usually awarded when the court feels like the defendant has acted in a harmful way. One juror even told reporters, quote, "There was a person behind every number, and I don't think the corporation was attaching enough importance to that, end quote. So really the reason that the jury awarded Mrs. Liebeck with so much money was due to the fact that McDonald's was not willing to change their policy on coffee temperature despite the numerous reports of injuries. McDonald's themselves admitted that they'd known about the risk of serious burns for more than 10 years as they dealt with other claims and lawsuits, but they felt that the number of burns were statistically insignificant when compared to the billions of cups of coffee they served each year.
I want to see these Excel spreadsheets so bad.
But it's like you are a company that is meant to serve your customers. It makes sense to say that something is statistically insignificant in a case where harm is not being caused. And something can be statistically insignificant, but still be substantial. You should care that 700 people have been burned by your coffee. It shouldn't take that number being statistically significant for you to make some sort of change.
Exactly. And it's usually very interesting because a lot of the precedent that is set as far as what people will and won't do really comes when people get sued, right? Or somebody does something that we as a society decide is not okay for the first time and it becomes a law later. That's usually what sets the precedent. So to me, it's really fascinating that the first time you got sued, you didn't take it seriously and just go ahead and bump it down. That's usually all the precedent you need to bump this down. And again, we're talking 3rd-degree burns. We're talking something that required skin grafts, which is an extremely long and painful procedure to have done. And apparently she's not the only one. That's crazy to me.
Right. And I think it was the fact that they'd been able to settle these out of court for the most part.
But that just makes me wonder, how much were they giving these people before her? If they thought it was appropriate to only award her $800 and they were aware of her medical cost, how much were they offering these other people who settled outside of court?
Probably pennies.
Exactly, because if that's the case, they are correct that it is less expensive to just let people bring the claims than to reduce the temperature of the coffee. If you can get away with giving burn victims $800, that's nothing, especially when you make $3 million in coffee sales in 2 days.
Right. So even though the $3 million amount was what made it to the headlines and what was socialized across the nation and even beyond the nation, the judge actually ended up reducing this amount by more than 80% to $480,000. And the judge did this because this was essentially 3 times the amount of the compensatory damages that Mrs. Liebeck received. However, this was not even the final amount. Mrs. Liebeck and McDonald's, likely to avoid years of appeals, ended up settling outside of court for a confidential amount that was reported to be less than the $480,000 ordered by the judge. And most of her settlement money went to paying for a live-in nurse because the burns, court proceedings, and subsequent media coverage really did a number on her. And all she'd wanted from the start was for McDonald's to help pay for her medical bills. And her daughter said that she'd never really regained the quality of life she had before the accident. Stella Liebeck passed in 2004 at the age of 91. So I feel like most of us know this story pretty well, at least the Cliff Notes version of this story. And that's because after that $3 million settlement amount was announced, the story went 90s viral and was picked up by many media outlets because of that large amount, even though Mrs. Liebeck never even saw that. And the way that the story was presented didn't really convey the real facts of the case. As I said at the beginning, Many people would say coffee is supposed to be hot. Or why was she driving and drinking hot coffee at the same time? Because the facts of the case were not being presented well. She wasn't even driving the car. The car wasn't moving. But these facts didn't matter to the reporters. The way that they presented this story also painted Mrs. Liebeck as a greedy opportunist who didn't deserve the millions of dollars that she never even got. And in many people's eyes, she'd abused the justice system. And in turn, she became the butt of the joke for many late night comedians and news anchors. Even members of the jury were receiving angry phone calls from people. But unfortunately, it did not stop there. During the 1994 elections, Republicans harped on this story and pitched a message termed the quote-unquote contract with America for Americans. This message surrounded a law called the Common Sense Legal Reform Act, which would place a cap on punitive damages and weaken product liability laws. The message that they pitched with this was, tell the legislature we can't afford another $1 million cup of coffee. This law also contained a provision called loser pays, which would require the losing party of a lawsuit to pay the winning side's legal costs. But critics of this bill rightfully stated that this would unjustly discourage the poor against suing anyone, regardless of if the defendant was a corporation or not.
Exactly, because in the United States, you have a right to sue somebody if they have wronged you. But do not try to pass laws that discourage me from invoking my rights as an American. How about that?
Right. Those rights that Republicans love so much when it benefits them.
Hello, because y'all love the Second Amendment. Stop it.
And this messaging, as well as the popularity of this story, likely contributed in part to the overwhelming success of Republicans in the midterm elections in 1994. Fortunately, President Clinton vetoed the Common Sense Legal Reform Act because he and other Democrats were able to see the damage that this would do to Americans who were trying to rightfully sue companies and other people who had wronged them. But Republicans also began funding civil groups to run ads about how, quote unquote, frivolous lawsuits led to fewer jobs and lower wages. This is a campaign that is still continuing to this day, and it aims to convince the public that the corporations aren't the only ones that are hurt when businesses are forced to pay people who are harmed by their products.
What?
And yeah, that is the corporate lobbyist talking in the Republicans' ears and trying to get them to make their base believe that, yeah, if they harm the corporations, they're harming you too. No, they're not.
You want to know the worst thing about this? Is that I can almost see their argument. I can almost see it. Where they lose me is this idea that corporations are something that need to be protected, and not the individuals who work for said corporation. Because again, even if this isn't the case, but even if McDonald's did have to pay out $3 million to this woman, they've already told you they can make that back in 2 days just selling coffee.
Right.
I really hate this whole idea that like brands and corporations and multi-billion-dollar companies are victims. These aren't mom and pop shops. That's where I could almost see it. I could almost see it if you were saying, like, if you sue Grandma Betty and Granddaddy Joe down the street, it'll close their business. I can see that side of it. We don't want to hurt a mom and pop, a small business. $1 billion corporation? I don't feel bad about taking $3 million from $1 billion corporation.
Right. Especially when all she was asking for at the start was $20,000.
Right. You've already established that 20,000 is nothing to you.
Exactly. And two, like the mom and pop shops aren't the ones that are forwarding these bills. The big corporations are the ones that are trying to get bills like this passed because it helps their bottom line. And we've seen so many cases in the past few years, like there was the case with the baby formula. And I forget which company that was, but people didn't have baby formula for months. That company needs to be held accountable. Because if they're not held accountable, they'll just do whatever is cheapest.
Hello. Because don't forget, at the end of the day, a corporation cares about their bottom line. And if it's going to impact their bottom line, they'll cut it out immediately. And that line of thinking should tell you everything you need to know. Because again, McDonald's had already done the math and decided that enough of their bottom line would not be affected if people just kept suing them. So sue away. It'll be fine.
Right. So today, McDonald's coffee is still sold at 180 to 190 degrees Fahrenheit, but they have that little warning sign on the cup that warns you that the coffee is hot. And they, along with other companies like Starbucks, Chick-fil-A, Dunkin' Donuts, and other fast food restaurants, still face dozens of burn cases every year. And so the reason I really wanted to tell this story was obviously the narrative that McDonald's and Republicans wanted us to hear was this woman was wrong for suing them and getting so much money. But the reality is corporations need to pay when their products harm consumers, especially when it is due to the corporation's own negligence and lack of regard for consumer safety. And that is the end of our story.
Wow. Thank you so much for sharing this case, Cam. I too was very familiar with this case. I thought I knew it very well. And I guess unlike most people, I heard she got $3 million and I was like, bet, good for her. Because again, they can afford it. Run her money.
Mm-hmm.
I never thought it was ridiculous, even with my limited understanding of the case, which was she ordered a cup of coffee. She opened it to put some sugar in it. She spilled said coffee. She got 3rd-degree burns. And I did know that they wouldn't settle with her, but I did not know the amount. And so she took them to court because they wouldn't settle. And as a result, she won $3 million. That was my understanding of the case. And I was like, bet. Because again, I'm just somebody who feels like I don't care about the bottom line of billion-dollar corporations. I don't care about making billion-dollar corporations' lives easier. I used to work at Ross, okay? People used to come through my line and claim anything, and I'd be like, cool, I'll give you 20% off. Because I don't care. I don't care about this billion-dollar company. My check was going to clear on the 1st and the 15th every time. So that's all I cared about. And it's so weird to me to go out of your way to protect a corporation and not protect people and protect the consumer. Because at the end of the day, what made you a billion-dollar company is your consumer. And you so clearly don't care about your consumer. Clearly, that is the last thing on your mind.
Yeah, and there are other examples of cases like this that are sort of brought up in the news for us to laugh at the plaintiffs. Like there is the example of the people who sued Red Bull because it didn't give them wings. But really, when you look into the case, that was metaphorical. They were saying, this is not giving me energy like the company is claiming that it should. But of course, the story, the tagline is going to be, yeah, people thought Red Bull was going to give them wings. And no, it's like there are, of course, examples of real frivolous lawsuits like the first story that I told. But many of the lawsuits that are brought against corporations have to do with real harm or misleading advertisements on the corporation's part. And also just to talk about the point of Americans being known for suing a lot. When people have done studies and compared the rate of lawsuits in the US, it really isn't much higher than other countries. A majority of the lawsuits in the US have to do with breach of contract cases and landlord-tenant disputes. Mm-hmm. They really aren't made up of these product liability cases that make it to the news.
Exactly. But again, that's all about messaging. They want you to think that there's just this influx of frivolous lawsuits that back up the court system. And that's why, you know, Sally's been in jail for the last 4 years fighting a case. Mm-hmm. And that's just not true. That's just not how it works. One, they're completely separate courts anyway. But two, that's just not how it works. And don't get it twisted. I have personally followed some frivolous lawsuits. I am the editor of a YouTuber named Natalie Lawyer Chick, and she has been sued frivolously twice. And she has been sued for a racist asked her if she was a racist, and she said yes. And that was defamation. And then she was sued by this other content creator for basically what boils down to a loss of Instagram followers. Okay? Those are frivolous lawsuits, right? But I would hazard to guess that most frivolous lawsuits come in the form of people suing people, not people suing corporations, because at the end of the day, most people are also well aware of the fact that corporations have corporation lawyers. There's a lot of money that comes with suing a corporation. Most people just don't want to be bothered, which is how these companies will get away with giving somebody $800 after giving them third-degree burns and requiring them to have a nurse for the rest of their life.
Right. And even in those cases where people are bringing frivolous lawsuits to corporations, they're going to get thrown out.
Right.
Because frivolous lawsuits are not going to end in the plaintiff being paid out.
Exactly. If the lawsuit was frivolous, it gets dismissed. I think that's another thing too. Like, people don't understand the court system. So people think that just because you filed a lawsuit, that it automatically goes to a jury and there's trial and court and whatever. There's a long wait time after a lawsuit is filed, because once a lawsuit is filed, it has to have a response from the defendant. And then both of you have to appear in front of a judge who will review said response. And the judge will determine if this requires either an amendment or dismissal or a jury trial. And a lot of times, some lawsuits don't even see a jury. Sometimes they will just give argument to the court, and the court will determine if the claim is valid or not. But again, I think with people's ignorance of our court system, and then people's just lack of understanding of how things work, and also people's refusal to do any ounce of research, is how you get away with perpetrating this whole thing that this woman was out to get a corporation or whatever stupid things people are saying. Because again, all I'm saying is, if my grandmother gets burned by a cup of coffee, we will own that local McDonald's. What do you mean?
Right. Because the issue in this case was, oh, you know, it's her fault for spilling it on herself. Okay, the thing is, if she spilled it on herself, it should not have caused her third-degree burns. That is the issue, point blank, period.
Right.
So, any other thoughts, friend?
No, friend. I think that's all I got.
Thank you to our listeners for joining us on this episode. I would also like to thank the Denver Post for providing information on the Jesse Dimmick case, and the Swindled podcast for providing a lot of the material for the Stella Liebeck case. If you'd like to check out photos related to these cases, follow us at Criminalish Podcast on Instagram and TikTok.
Listeners, if you like what you hear, be sure to tell a friend and leave a 5-star review wherever you're listening to the Criminalish Podcast. And if you're listening on YouTube, please be sure to subscribe to our channel and feel free to leave any comments or questions below. As always, stay nosy, my friends. Bye.
Bye.